Thank you, Mr. Chairman. Again, as you just stated, this bill amends Title 38 of the U.S. Code to prohibit discrimination and acts of reprisal against persons who receive treatment for illnesses, injuries, and disabilities incurred in or aggravated by service in the uniformed services. Mr. Doggett of Texas introduced H.R. 466 on January 13, 2009. The bill would expand USERRA protection to include service members and veterans who have an illness, injury, or disability determined by the Secretary of the Department of Veterans Affairs to be incurred in or aggravated by military service. This bill is an important bill that strengthens reemployment rights of veterans who bravely serve their country in the armed forces, have suffered an injury due to that service, and through this bill, these veterans are protected from unfair reprisals and job loss because of service and injuries. Mr. Chairman, at the appropriate time, I will have an amendment in nature of the substitute.
Thank you, Ms. Herseth Sandlin. Does anyone else want to be?
The nature of the substitute to H.R. 466.
Is there objection to the gentlelady? Without objection, so ordered. The amendment has been provided to each of you. I ask unanimous consent that the amendment be considered as read. Without objection, so ordered. I now recognize the gentlelady in support of her amendment.
Thank you, Mr. Chairman, and let me thank Mr. Bozeman, the distinguished ranking member of the subcommittee, Mr. Bouyer, who we also work closely with, as well as the chairman of the full committee, Mr. Filner, as the Department of Labor raised some issues after this bill came out of our subcommittee for the purpose of clarification. And so the amendment that I offer today clarifies the intent and the goals of the bill and aligns the legislation with current protections, as Mr. Bouyer noted, available under the Uniformed Services Employment and Reemployment Rights Act. So with this amendment, service-connected disabled veterans who seek medical attention would have the USERRA protections for seniority, status, retention and pay, as well as other rights and benefits determined by employment. And furthermore, this amendment provides important protections for our nation's small businesses. Instead of placing a time limitation on how long a veteran can miss work while seeking treatment for his or her service-connected injury, this amendment provides the employer with the opportunity to show such retention would impose an undue hardship on the employer. Again, I applaud Congressman Doggett's efforts on this legislation, and again, thank him as well as Mr. Bozeman, Mr. Bouyer, Mr. Filner, again, for all of us working together to craft an amendment that adds to Mr. Doggett's vision and creates additional protection for the members of the armed services who are seeking to re-enter the civilian workforce. So again, I thank the Chairman for including this bill in today's markup and urge all of my colleagues to support this amendment.
Thank you. Are there any questions on the amendment? Is there further to explain the bill?
Thank you, Mr. Chairman. And again, I appreciate that H.R. 1088 has been included in today's markup. I was proud to introduce this bill, the Mandatory Veteran Specialist Training Act of 2009, that will improve employment services available to veterans through the Department of Labor. This bill addresses this issue by changing the training requirements for disabled veterans outreach program specialists and local veterans employment representatives. Currently, these individuals are required to attend a specialized training program, the National Veterans Training Institute, within 3 years of being employed. This bill changes the requirement to 1 year. The NVTI program is designed to provide the necessary skill sets so employees can help veterans through a variety of services. Courses offered address the following issues: veterans benefits, transition assistance, case management of veteran services, and employment assistance. Mr. Bozeman and I and others on the subcommittee learned through a hearing that we held that it was taking on average 2.5 years before individuals were completing the NVTI program. So this leaves untrained specialists who don't have the necessary skills trying to help veterans with their employment needs. So the Mandatory Veteran Specialist Training Act of 2009 is a well-crafted bill informed by our subcommittee hearing process that will provide veterans with the employment assistance that they deserve. So again, I thank the Chairman for including this bill in today's markup and encourage all of my colleagues to vote in favor of H.R. 1088.
You are recognized to explain the bill.
Thank you, Mr. Chairman. And again, I want to thank Chairman Filner for including H.R. 1089 in today's markup. This is another bill that I was proud to introduce that came out of hearings that Mr. Bozeman and I held in the last Congress, as well as this one, to give the U.S. Office of Special Counsel the primary authority to investigate federal sector USERRA claims for veterans. Under a demonstration project established by Public Law 108-454, the Office of Special Counsel began investigating some federal sector USERRA claims in 2004, and the results were very promising. OSC obtained corrective action for service members in more than 1 in 4 of the claims they investigated, and took less than 120 days on average to resolve the cases. So those good results show the value in granting the OSC exclusive jurisdiction over federal sector USERRA cases. This switch benefits federal employee claimants since they would have just a single agency resolve their claim instead of the current circumstances where first the Department of Labor investigates the claim, only transferring it to OSC if no resolution can be found. The demonstration project expired December 31st, 2007, and this bill makes the OSC the primary authority to investigate federal sector USERRA claims. This bill is a strong bill that correctly allocates resources in order that veterans who are seeking redress under USERRA in the federal sector get their claims resolved in a timely and fair fashion. I again want to thank Mr. Bozeman for working so closely with us over the last 2 Congresses to address this issue, and would encourage all of my colleagues to vote in favor of H.R. 1080.
Thank you, Mrs.